A bit more than 2 years ago, when the United States Supreme Court ruled that same-sex marriage was legal. It was not the end of the conversation, though, as many more lawsuits have been filed since then, arguing one point or another around the notion of and the laws and benefits supporting the marriage of couples of the same sex. One of those lawsuits was here in Houston, where two taxpayers argued their tax money should not be used to support any benefits for same-sex couples. Jared Woodfill was the attorney for those taxpayers, and it went to the Texas Supreme Court. Jared, good to see you.
Good to be with you, Kimbrough.
It's been a while,
hasn't it? It has. It's great to be back.
You're always in something, though. And so now this one, the Texas High Court ruled that, in essence, that same-sex couples had no inherent right to taxpayer-subsidized benefits. That was not the final word, though. We're always seeing lawsuits being filed on one hand or another about those kinds of things. What was it about the initial rulings in this court case that made you decide to go forward and feel pretty confident that you might be able to win?
Well, you go back to day one. In 2013, when we filed the lawsuit, Mayor Niece Parker at the time decided to just ignore the law, ignore the Texas Constitution, which said marriage is between one man and one woman, ignore the Texas Defense of Marriage Act, and in fact, the city charter, Article 2, Section 22.
Is this all about the Texas as opposed to the Supreme, which is the federal level?
Well, that's how it started, though. It started here in Texas in a state court. We filed an injunction. Now, this was pre-Obergefell. And we said the mayor...
Obergefell, for those who may not know what that
was the case that recognized the fundamental right to a marriage license.
Across 50 states.
That's true.
Right.
So what we did was we actually took her to court, because at this time the law was, as I described it previously. The judge agreed with us, said that what the mayor had done was unlawful and illegal. It went to the Court of Appeals. The Court of Appeals then reversed the trial court. We then took it to the Supreme Court. And it's as you described it. The Supreme Court looked at the issue, and the city had been arguing that Obergefell should be extended to benefits. Well, that's not what Obergefell said. So the Court of Appeals was wrong, and the Texas Supreme Court said they were wrong. And so it was an attempt by the city to get the Obergefell decision expanded into an area that the High Court chose not to go.
Now, in the Obergefell, which I typically don't use those technical terms, but in that decision, it was in 2015, making same-sex marriage legal across the 50 states, right? That was a federal decision now. And in that, they talked about equal dignity and all benefits associated with it. That was a part of their wording. So when I see that happening, I think, okay, well, I understand that. But somehow, what was the legally weak part that you saw that you wanted to go ahead and contest?
Well, the point in Obergefell was that same-sex couples had a right to a marriage certificate, and that's where it ended. Now, our case specifically goes and talks about benefits. Now, there's never been a fundamental right to benefits. Governments distinguish on benefits all the time. Whether you're 65 or older will affect whether or not you get benefits from the city or from Medicaid, Medicare.
When they worded it such that they should be married, opposite-sex couples should have the same benefits as same-sex couples, you're saying that they didn't mean benefits as we know.
Well, read the clear language. They didn't even say that. In fact, the Texas Supreme Court said that was never addressed in the Obergefell decision. What's interesting, though, is that in 2005, Texans overwhelmingly said, in the form of a constitutional amendment, Article 1, Section 32, that marriage is between one man and one woman. That passed with 76% of the vote. This happened all across the country in various states. 2013 or so, the U.S. Supreme Court said, yes, marriage is the province of the state. It was a 5-4 decision then. And then you have Obergefell. One justice changed his mind, Justice Anthony Kennedy, and undid the votes of millions of Americans all across this country.
So the whole thing, though, when you talk about the Supreme Court, they typically are considered the law of the land. And you're looking at it from the standpoint as a federal law as opposed to states' rights kind of situation. Is that what it comes down to?
It's broken up into two issues.
Because you can't get, if you're going to observe someone and say you're married, and then you say you're married, but you're not really married as it relates to getting benefits. I mean, I'm playing devil's advocate.
I totally understand what you're saying. But see, the distinction there is Obergefell did not deal with benefits. Benefits, there are no fundamental right to benefits. People are treated differently with respect to benefits all the time. If someone's a smoker versus a non-smoker, that person is treated differently with respect to benefits.
Knowing what you know now, based upon what the Supreme Court has ruled up to this point, what do you think your chances are when it gets to that point? because I think both of you and I agree that this is not going to end at the Texas Supreme Court. Agreed?
Agreed. It's going to the U.S. Supreme Court. Ultimately, the question is when. And who knows what the character of the court will look like at that time. We know that things can change with one person changing their mind. In this case, Anthony Kennedy decided to change his mind over a 2-year period, undo marriage amendments all across the country that states had passed. We know that the character of the court is likely to change under the Trump administration. So by the time this case gets there, it will depend on what the composition of the court makeup is.
One thing about the Texas Supreme Court is that at one point they ruled 8-1 that they weren't even going to take this case up. And then there was political input from the governor, lieutenant governor, and a lot of other people about that. I know you're not concerned about it because it helped you in this case, but political involvement on the judiciary level, at what point is that going to be a problem for the way we govern? You know what I mean? Because at some point it could go the other way.
But let's look at what really happened there. So yes, the governor wrote an amicus brief. The lieutenant governor, the attorney general, numerous representative state legislators signed on to an amicus brief in conservative organizations. But at the same time, so did a whole lot of folks who had a different view. So I think the Supreme Court looked and said, wow, look at all of these people who decide to weigh in on this issue. It must be an issue that's important to the jurisprudence of the state. We probably need to relook at this and decide. So the fact that so many different groups from both sides of this issue chose to write amicus briefs or friend of the court briefs, I think caused the Supreme Court to say, hey, maybe we should look at this.
All right, got a minute left. I know you talk about the legislative session, special session coming up. What is it that you're most interested in seeing come out of that session?
Well, as you know, we had the hero fight here in Houston, and we overwhelmingly passed legislation or successfully kept biological males who believe they're a woman any time from going into female restroom showers or locker rooms, girls' restroom showers or locker rooms. You saw that legislation.
Has there still been a case at all? I mean, has there been a case? I know the laws were out there.
There was one just recently up in the Woodlands, in a Target in the Woodlands, and we've seen lots of incidences of that.
There are laws already on the books for that, though, right?
Well, no, there all aren't in the books on that, and that's one of the things that we're arguing. And SB 6, which passed in the Senate overwhelmingly, 21-10, then the governor has made it a priority, died in the House. And so that's one of many issues. School choice, again, something that came through the Senate, dies in the House, is now another priority of the governor. And the thing is, you have in the House a speaker in Joe Strauss who is single-handedly killing good legislation that has been passed in the Senate that is a governor's priority, and one man shouldn't have that much power.
I get the sense that Mr. Strauss is in your bullseye of you and other conservatives who feel
he should be in the bullseye of every single conservative Republican or every person who believes in good government and that their elected representatives should vote on issues, because he's not allowing us to vote.
You know what, if you could just have an opinion one of these days, come on this show and have an opinion.
Well, thank you for letting me voice it.
Jared Woodfill, always good to see you here. Thank you so much.
Thank you, Kimbrough.
You know, your law firm is a small size, but that's not a problem for our next guest coming up. If you want to